Hey, in this video, we're going to talk about what I look for when I help a family start a probate. I know this is more about me, but when I talk about what I look for, it should help you if you're in the process of starting a probate, or maybe even you're just trying to get your affairs in order to make it easy for your survivors. But I thought I'd share with you what I look for instead of, most of my videos are all about you could do this, you should do this, here's some suggestions. This is really what I look for. But I think this is going to help you. You can tell me in the comments below. All right, before we get started, I get a chuckle. I got my first comment that made me laugh to a video about a week ago where Gilda said she'd been binge watching my videos, and that just made me chuckle. And I mentioned that on one of my videos, and now 2 more people confessed that they've been binge watching my videos. So thanks Patricia Ann for binge watching my videos from the state of Washington. And then have another individual who said that they're studying to become a notary in my state of Louisiana. And they say they've been binge watching my videos while preparing for the notary exam. So I think your name is Danger. When you pass the notary exam, make sure you let me know. I want to be the first to congratulate you. In fact, I've got 5 kids. My second oldest, Taylor, he graduated from law school several months ago, and he took the bar. And the day he found out he passed the bar exam, we went to, of course, a bar, and all of his law school friends that had passed the bar also were there, and many of them told me that they watched my videos to prepare for the bar exam, at least kind of the estate component of the bar exam. So I thought that was pretty cool. So if you're binge watching, let me know and you'll make me chuckle. But so all right, back to what I look for when I start a probate. And again, a probate is necessary when somebody dies. Let's say they had a will and they had assets that need to be divided up among the heirs or distributed to the heirs. And so there's a procedure that we follow. And so there's maybe 4 or 5 things that I look for. The first thing that I look for or that I want to see is the will. And we've had issues where people think they bring in the original will, but they bring in a photocopy. We need the original. So I'm always looking to see if it is a photocopy or is it the actual original, which perhaps may have a notary seal embossed on the signature page at the end. It may be signed in blue ink. You can kind of tell an original from a photocopy oftentimes. Sometimes you can't these days. So I'm looking for that original will, and in that will I'm looking, the will might be 1 page or it might be 60 pages long. But I'm going to take a quick glance at that will because I'm looking for the bequests provisions, how they're leaving their stuff. I'm looking for the executor appointments. Who did they name as the executor? And is that person, sitting at the table with me, or is that person available to be the executor? And if not, is there a alternate executor named? And then I'm taking a quick look at the will to make sure all of the validity requirements are met. Does it have the appropriate language that makes it a valid will? Was all the signing appropriate with the notary and the witnesses and all of the pages and all of those things that we look for to make sure that it's a valid will and that a judge will sign off on the fact that it is a valid will. So I'm looking at that. Okay, so once we get through that and really discuss that with the parties, then and get them on the same page as far as what the will says or what the substantive provisions of the will or the provisions of the will that are really going to be applicable. The next thing we move on to, or the next thing that I look for, is I want to get an understanding of the assets and debts, if any debts, of the person who died. And so what that's going to help me do is that's going to help me determine whether there needs to be what's called an administration of the estate or the probate or the succession. And then I'll also inquire whether any of those assets need to be sold. So all those questions like, okay, so I realize, Dad had a home. What do you plan to do with the home? Do you plan to keep it or do you sell it? I know Dad had a vehicle, and so what do you plan to do with that? Do you plan to keep it? Do you plan to sell it? He had stock. Do you plan to sell that or just distribute the stock in kind to the heirs? So when I get answers to those questions, then I can, it helps me better formulate a plan to get things done from start to finish. And then the next thing that I'm going to ask about is whether anyone has access to the bank accounts. So, sometimes Dad will always have bank accounts. He may have a checking account, he may have a savings account. And sometimes, in fact, in many cases, Dad will have brought one or more of the children to the bank and added them as a signer on the bank account. And in that case, and when it works, then the bank doesn't freeze the account when Dad dies. The child who is an authorized signer, if the bank permits it, can continue, operating out of that account and pay Dad's bills, pay Dad's funeral expenses, pay the ongoing household expenses, the cable bill, the light bill, the water bill. They can pay that out of Dad's bank account rather than the heirs having to, come out of pocket to pay Dad's expenses. So always inquire whether somebody's got access to some funds, because if they don't, then the heirs tend to get a little bit more stressed as delays go on, if delays go on. So I always want to find out if someone has access to accounts. And then the real thing that I look for, probably the most important thing that I look for, is are all of the parties amicable, cooperative? Are they present in the conversation? That makes all of the difference in the world. So years ago, I had to learn my lesson the hard way. Years ago, a dad would pass away. Dad had 4 children. He had 4 heirs. He had a will leaving things to the 4 children. 2 of the children would come in. They'd tell me, our 2 children don't live here in town, but we're going to go ahead and get things started. And then, I didn't ask the right questions, and we'd get started, and all of a sudden, the 2 who weren't there started not only asking lots of questions, but were very uncooperative. And that's when, you hear the horror stories about probate. That's when that happens. And so that, when there's 1 or more who are uncooperative, that adds years to the estate settlement process. Now in my practice, we do it different. So when we get a call about a prospective probate that a family may want us to help them with, we're going to ask the question immediately, how many heirs, how many children? All right, we need all 4 heirs present at that first meeting. Well, 2 of our siblings live out of town. Let's get their phone numbers and let's conference them in. Boy, with smartphones these days, it is a piece of cake, because we want all of the parties present. And so if people have concerns up front or questions up front, those questions can be asked among the 5 of us, me and all 4 of the participants. So there's never any he said, she said when everybody's involved in that conversation as to what the will says, what the assets are, what the debts are, who has access to the accounts, how are things going to be dispersed, how long is this going to take, what paperwork do y'all need to sign, how many times will you need to sign paperwork, do you need to come into town, can we do this from wherever you are, can we send you paperwork? All of that stuff is addressed with all of the parties. So if I do talk to 2 heirs and they tell me, yeah, we're here, Paul, we want you to help us with the probate. Dad had a will leaving things to all 4 of us, but 2 of our siblings, they don't talk to us. And I think they're going to be a problem. Then, my response is, see you later. It's not that I can't help you, it's that I don't want to help you. Because a probate where you have uncooperative parties, I don't want to be in the middle of it. I've lost most of my hair, and if I get involved in any more contested probates, the rest of it's going to be history. So just a business decision I made. My kind of specialty is getting all the parties on board, communicating very clearly and very openly about what's going to happen, and getting all that information up front, and then laying out a plan to get things done, and then just following that plan so there's never any surprises. Okay, so when we get all of that participation among all of the heirs, then the next step is to develop that plan to get the entire estate settled from start to finish, which typically includes getting the executor or co-executors confirmed, which is preparing a bunch of court paperwork, filing that court paperwork with the will at the courthouse, having the judge to sign an order that the will is valid, confirming that the executor, signing the order, confirming that the executor is the executor. And then from there, the executor typically opens an estate account and then pools all of the funds of the estate into the estate account. And then we get all of the information to compile that inventory of assets and debts, commonly called the detailed descriptive list. And then working toward that final court order or that final judgment of possession that a judge signs, that we prepare, order where the judge orders that assets be dispersed to the appropriate people. And so we get everybody involved in that plan, and then once the plan is agreed to amongst all the parties, then we just move forward with transparency. So if substantive issues come up as we're moving forward, maybe something wasn't addressed in our initial discussion, or something was discovered, and it's an issue that's going to affect everyone in some significant way, then I'm going to want to make sure we have a conference call and get all the parties on board, have a conversation. I tell the heirs, I'll tell them, one of you can't call me and say, "Don't tell my sibling I told you this." If somebody calls me and tells me that, I hang up, because I tell them in advance I represent all of the heirs, and you can't tell me something and tell me not to tell somebody else. So if there's substantive issues that comes up, have a meeting with everybody, a conference call with everybody. All of the emails related to getting the probate settled will be group emails. And I tell them, if you're going to reply, hit a reply all. So everybody's involved in the communication. And that really works well, because when things get testy with the probate, it's because people don't know what's going on. And when they don't know what's going on, they get this sense that something's wrong. And then that leads to a distrust. And so, like Dear Abby said, if you want to really get to know somebody, share an inheritance with them. But if we can keep that communication really wide open, that just eliminates all that stress and anxiety that comes from not really understanding what's going on and not really knowing what the steps are that are going to take place in the future to get things completed. And then there's a lot of peace of mind when everybody knows that their interests are protected, because there's just no secrets and everything's wide open. So that's really what we want to look at. We want to look at the will, make sure it's the original. We want to find out what the person owned and owed. We want to know if someone has access to the money, and we want to make sure all of the parties are present, amicable, and cooperative, so we can create a plan to move forward and then move forward with transparency. That's the way it really needs to be done to make that probate process, which some people, scares some people, because there's, everybody has a nightmare probate story. Those are the steps that we take to make this estate settlement journey as smooth as it can be, and rather than have relationships go sour, we want to see them prosper through this process. Okay, so make sure you just smash the subscribe button and then the notification bell. If you've already done it, thanks. Our subscribers numbers are going up every day. And then 10 o'clock every morning, Central Time, new estate planning video, new estate planning education to keep you informed on how to protect what you have and protect your family and what you've worked for. So we'll see you tomorrow. Have a great day. Take care.